Hey there, Legal Tea listeners. This is your host, Jenny Roselle. We are back to the estate planning of the rich and famous, where we chat about celebrities and their estate planning. And most of the time, I feel like we're talking about celebrities and their poor estate planning tactics. And if you recall from last estate planning of the rich and famous episode, we talked about Michael Jackson. And truth be told, he didn't do a terrible job. Today's episode is on Kobe Bryant. And Kobe is actually about the same way. He didn't do a terrible job, but he doesn't get an A+ either. Let's dive into Kobe and his estate plan, shall we? First, we're going to talk about Kobe and his family. Kobe was married to a lady by the name of Vanessa Bryant. And according to Kobe's Wikipedia, he and Vanessa met in 1999. He was 21 years old at the time, and she was 17. 6 months later, they got engaged, and a little bit more time passed, and on April 18th, 2001, they got married. Subsequently, the couple had 4 children: Natalia, Gianna, Bianca, and Capri. The oldest, Natalia, was born in 2003, and the youngest, Capri, was born in 2019. On January 26, 2020, Kobe, along with his daughter, Gianna, and she was often called Gigi for short, so if I interchange her name, I'm talking about the same person. So Gianna was traveling to another county in California by helicopter, and they were going to attend a basketball game. They were not traveling alone. They actually had 6 family friends with them too, and of course the pilot. The weather that morning was less than ideal. It was rainy, it was foggy, and actually most air traffic was grounded due to the weather. So the helicopter took off at 9:06 a.m., and by 9:30 a.m., the pilot communicated with the nearby control tower. The controllers at the control tower told the pilot he was flying too low. And at 9:45 a.m., the helicopter crashed into the side of a mountain and tragically killed everyone on board. I often think, am I ever going to come across a celebrity, a famous person that gets an A+ for their estate planning? And it finally hit me. The answer is probably yes, they exist, but we just probably won't know about what went down with their estate plan. After all, those that would get an A+ are the ones that don't hit the news, right? When individuals have a solid estate plan, their mistakes aren't made public because things are settled nice and privately. On the surface, when I started researching for this episode on Kobe, I was like, okay, this is good. He did good. And then I stumbled upon his estate plan and where his mistake occurred. So here we go. According to a blog from the law office of Jordan W. Jacob, an attorney in the state of Florida, Kobe had actually established a living trust to, quote, protect his assets, reduce estate tax liability, and pass on his wealth to his family, end quote. It was called the Kobe Bryant Trust. The purpose of the Kobe Bryant Trust was to support his wife, Vanessa, and their children upon his passing. And expressly, it stated that Vanessa and the girls could take both any principal and any income from the trust while Vanessa was living. Then, upon Vanessa's passing, the remaining trust assets went to their children. That sounds all fine and dandy, I'm sure. Except here comes the part Kobe missed something. So the trust was originally established in 2003, shortly after the birth of their first child, Natalia. After each child was born thereafter, he would amend the trust to include the newborn. Except he had not gotten around to amend the trust to include their youngest child, Capri. If you run the math, Capri was a mere 6 months old when Kobe passed away. I'm just so sure that Kobe thought he'd get around to it, that he had time. After all, he was only 41 years old when he passed away. But he didn't. He ran out of time and it became too late. Still according to Jordan W. Jacobs' blog, the trustees of the Kobe Bryant Trust are Vanessa and a dear friend of Kobe, Robert Palinka Jr. Because the trust had not been updated to include Capri, the only way to change or amend the trust at this point is to involve the court. So Vanessa and Robert petitioned the Los Angeles Probate Court in March of 2020 to request that the trust be changed to include Capri as a beneficiary. If the court would disagree, and if the court would stand by the standing trust document, Capri would not be allowed to inherit from the trust, which is reported to be in the neighborhood of $600 million. The petition that Vanessa and Robert submitted included evidence to show that adding Capri would have been the intention of Kobe. The evidence provided to this court specifically was showing that Kobe amended the trust after every child's birth. He did it after Gigi was born. He did it after Bianca was born. And his intention would not have been to exclude Capri. Thankfully, the court agreed with their argument. And according to ET Online, the court approved their request and allowed for Capri to be added as a beneficiary of the Kobe Bryant Trust. This misstep, though, I'm sure cost some serious dough. Money, that is. Specifically, court costs and legal fees are what I'm talking about. I'm rather certain that had Kobe gotten around to amending his trust to include Capri as a beneficiary, he very well may be one of those A-plus celebrity estate planners. We may have never heard about his estate plan, and I probably wouldn't even be doing this episode. But here we are. His estate plan got exposed, all while his wife and family were trying to grieve from his tragic passing. And I'm sure the very last thing he would have wanted would be to have Vanessa and Robert involving the court, because goodness sakes, they needed privacy to grieve. The lesson from Kobe clearly is to keep your plan updated. Step 1 is to make sure you #do your estate plan. And step 2 is to keep the darn thing updated. Clients often ask me how often an estate plan should be updated. Actually, as I write this, the very last client meeting I was in, the client asked how routinely they should update it. And I responded to them, well, attorneys will answer this question all over the board. So here's my answer. And I proceeded to share with them what I'm about to share with you. Some attorneys will say, oh, you should update your plan every X number of years. So like say every 5 years or 10 years. Truthfully, I don't really like to say a number. I actually often recommend to look out for big life events. And depending on the life event, a change to your plan may or may not be necessary. So what are some examples I'm talking about for life events? I'm going to name a few, so here are some. New children, cough, cough, Kobe. New grandchildren. New family members, maybe I should say very generally speaking. New assets. And specifically, how are those new assets owned, or how are they beneficiary designated? Do they support your overall estate plan? Do you have a new asset that is maybe a property in a different state? Have you moved so your asset has changed? Have you received an inheritance? Have any relationships fizzled? Meaning, is there someone in your estate plan, family members, beneficiaries, that are now estranged and you don't want them included? What about marriages? What about divorces? What about health? Health things. So have you gotten a diagnosis that maybe we should re-examine some things? What about cognitive impairment, like dementia or Alzheimer's? What about health things of your beneficiaries? Maybe some kids or beneficiaries may be dealing with some special needs. Have you considered how they inherit and what kind of impact an inheritance would have on them? I get it. That's a lot to watch out for. And as we all know, life has a way of going really, really fast. And before you know it, a few of these things may apply to your world. So for that reason, that is why some attorneys say X number of years, because they'd rather not sort of count on the client to remember that, hey, this life event occurred and I should go see my lawyer. And I truly see both perspectives. I see the whole X number of years argument, and I also see the look out for life events argument. And just like everything else in life, there are pros and cons about both. Something I'll mention is that my firm has a voluntary and optional program that we call our maintenance program. And super long story short, a year or so after a client signs their estate plan with us, we offer them to remain in our maintenance program. So we automatically enroll them when they sign, and then about a year or so later, we offer to them if they would like to remain in the program. To remain in the program, there was a minimal annual fee. The program entitles the client to a host of benefits. But some of the most popular reasons that I hear from clients that remain in, some of the most popular reasons that they choose to remain in are, first, they get an annual meeting with our office. So that the purpose is to keep them, the client, accountable on changes in their world that may necessitate changes to their documents. Second, there's no fee beyond the program fee. There's no fee for changes to the documents. So do you need a new document? You need a new version of a document? There's no problem, no charge. Third, if there's a change in the law that impacts our little estate and elder law world, we get a hold of our maintenance program clients. If a client is not in the program, once the estate plan is signed, our attorney-client relationship, truly from a legal, ethical standpoint, is over. It's terminated. So the maintenance program allows for that attorney-client relationship to stay intact, to continue. And lastly, after the passing of the client, and if the family needs our assistance, their fee is capped at a reduced fee than for non-maintenance program clients. So I share all this with you to say that if you #do your estate plan with someone else, whether it's you're in a different state, my voice annoys you on Legal Tea podcast, inquire if they have a similar program. Some attorneys do, but most do not. I think truly the numbers speak for themselves. We've actually been offering this program to clients for, probably over 10 years at this point, and every single year it has a retention rate of like 80 to 90%, meaning 80 to 90% of clients, after they sign their documents, they see the value in the program and they remain in the program. So if there's anything I hear about the maintenance program, the clients that choose to remain in, they often say, Jenny, there's just no dollar you can place on my peace of mind of this stuff. And that's what the program gives me. Alrighty, let's wrap up this episode, shall we? So next week's topic is a cautionary tale, a real life case that I've personally worked on, and I promise it will be a good one, which I think I say that after the end of every episode, but I hope that it holds true. So yeah, it'll be a good one. So stay tuned. Until then, Legal Tea listeners, take care and be well.